Time being 6:08, we'll open the meeting for the month of May for the Tilton Zoning Board. And without laboring the situation at all, we left the last meeting in a deliberative form. And so we're going to stay in that motion, and we'll be open to the public at this point in time. We'll continue our deliberations as a board. The first thing I would ask is, are any of the board members feel like they need to disqualify themselves?
No.
You're good? Even with your connection with, excuse me?
I am fine, thank you.
Okay.
Mr. Chairman, with understanding that this isn't a public hearing portion of it, I would, for the record, like to file an objection to Mr. Gallant sitting on the board tonight, as he is an agent for Director Butter, which would be the town, excuse me, of Tilton, and works for the town of Tilton. And under the statutes, that would disqualify him to be able to sit on this particular application.
Well, I mean, it's so noted. However, you can't disqualify him, and I can't disqualify him. You understand that legally, right?
Yeah.
Okay.
Yeah. I just want to make sure that the record is clear that the objection is made.
It shall be noted.
Thank you, Mr. Chairman.
In that case, what I'm going to do here is, as we left the last meeting, it was based upon our obtaining a legal opinion relative to the questions at hand. And in front of me, I will make this public, both what I'm going to read and also at the end, the entire opinion will be available as necessary, because we want the public to, by the planning board, to have it also. Question?
Just a suggestion that your board vote to make it public, because it's an attorney-client privileged information.
You're right, at the end we will do so.
But if you're going to read it now, this board should vote now to make it public. Because only the board can do that, one person can't. And I don't hear that you've made it.
Okay, that's a fair enough.
Yeah,
point.
just to cover.
Okay, so in that case, like a motion to make this legal opinion available to the public after the meeting?
Second.
Okay, any discussion? All in favor?
Aye.
Aye. So noted, thank you. What I'm going to do here, the way I'm going to address this is not, instead of trying to read the whole thing and then go back on it, I will cover each item as the attorney covered it in the letter. Okay? And I'll read it to you as close to verbatim as I can. It is addressed to myself and the board members. I've been asked to provide guidance regarding the interpretation and application of the Town of Tilton Zoning Ordinance setback provisions in relation to motor vehicle parking on the property located at 570 Laconia Road. The primary issue to be addressed is whether off-street parking and a driveway to that parking may be located within the 20-foot setback required by the Tilton Zoning Ordinance. The first issue that I asked Mr. Van Creen about was a point brought up as to whether this board even had the authority to deal with an appeal to administrative decision. And the first point is, has the planning board made an administrative decision that is appealable to the ZBA pursuant to applicable New Hampshire law? In his discussion and analysis, pursuant to the Tilton Zoning Ordinance 11.3 and RSA 676.5:1, the ZBA has jurisdiction to hear an appeal from an administrative decision by a person who is aggrieved. Clearly, the property owner would be aggrieved and qualify for status to appeal the decision if a decision has been made that parking and/or a driveway may not be located in the applicable 20-foot setback. The question is whether such a decision has actually been made. Initial step requires reference to RSA 676:5 and numeral 2B, which states a decision of the administrative officer includes any decision involving construction, interpretation, or application of the terms of the ordinance. It does not include a discretionary decision to commence formal or informal enforcement proceedings, but does include any construction, interpretation, or application of the terms of the ordinance which is implicated in such enforcement proceedings. The planning board, excuse me, the planning board minutes of December 13, 2011, referring to this matter, indicate that Mr. Bernard stated he wanted to amend the plan to take the parking area outside the 20-foot wetland buffer zone. That reference apparently refers to the requirements of section 14.4.3, which arguably more stringently require not only a setback, but also require the buffer to be left ungraded and undisturbed. Including in the materials provided to me is an updated plan with hand-drawn lines indicating that the driveway and parking would be outside the wetland buffer setback. It is not clear if this plan was shown to the planning board. Nonetheless, based on the description of the subsequent discussion, that was my discussion with him, it appears that the planning board motion to allow Mr. Bernard to meet with the ZBA for a variance is reasonably clear indication that the planning board interpreted the Tilton Zoning ordinance in a manner that would require issuance of a variance to locate the driveway and parking in the revised location, such as outside the wetland buffer, but still within the generally applicable setback under the dimensional table in Article 7. Therefore, it is reasonable to conclude that the ZBA does have jurisdiction to proceed with a consideration of the matter, even if the motion did not express with absolute clarity a definitive view of the setback requirements. That being said, is that we can act on that appeal to administrative decision. And at that point, I would ask the board if they have any comments relative to this so far. Nothing? Okay, well, in that case, I think we can move on to number 2 then. We can deal with this issue. Does the town of Tilton zoning ordinance in any way prohibit or restrict the location of driveways or parking of vehicles in areas that are delineated as setbacks? Page 3, parking and driveway location is setback. As apparently recognized by the property owner, the wetland buffer setback is worded differently from the general setback requirement in that it prohibits alteration of the land. As the relocation of the driveway and parking area outside the wetland buffer eliminates issues with regard to that requirement, the sole interpretive issue is whether the Tilton zoning ordinance permits or prohibits parking and a driveway in the setback. While there are no New Hampshire court decisions directly interpreting this language, there are New Hampshire cases dealing with related matters of parking that do indicate the prevailing view here would be consistent with the general law as follows. Accordingly, it is appropriate to look to other sources for guidance in interpreting ordinance setback provisions that do not expressly bar parking in the setback. A number of standard land use references agree with the general rule, which may be stated as follows. Ordinances that require specified yard space or impose setback requirements frequently fail to specify what may or may not be done with the space reserved. Whether the space may be used for the parking of automobiles may be unclear, even where yards are defined as open space or an unoccupied area. Absent a specific provision excluding off-street parking, such space may be provided within the yard or setback lines, according to his reference of American Law of Zoning, 5th edition, 9.65. Emphasis added to, well, you wouldn't have that. A similar view is expressed in 3 Rathcop Law of Zoning and Planning, 5314, American Juris 2nd Zoning, 144, where an ordinance imposes yard requirements in terms of open, unoccupied space on the same lot with a main building. The property owner may nevertheless use the required yard space for parking of motor vehicles and may improve it for that purpose. These references note that setback lines are said not to relate to the character of the use to which property may be put but only to the construction of buildings and structures. Accordingly, they do not confine the use of the land so as to prohibit parking within the setback limits, according to the American law of zoning. As the Tilton zoning ordinance language strongly parallels the language cited in these standard land references, it is reasonable to conclude that a court would interpret the language to allow parking, particularly in light of the more stringent requirements of the wetland buffer. The last issue here, or the third issue I should say, how should vehicles be considered when referred to in the zoning ordinance? For example, should they be considered as structures? Treatment of vehicles, as noted in my discussion on the analysis of the setback parking issue, setbacks and related provisions of zoning ordinances primarily deal with structures and buildings. While the definitions in the Tilton zoning ordinance, if stretched to their outer limits, conceivably could include a vehicle, it is fair to state that most courts interpret the word structure and building to mean something that is constructed or installed on land. Thus, the American law of zoning notes that setback lines are said not to relate to the use to which the property may be put, but only to the construction of buildings or structures. One case from New York State noted the setbacks normally deal with issues such as porches, which are not comparable to automobiles or other highly mobile chattel, but permanent affixed structures. It is, however, extremely important to note that the zoning power may be used to regulate parking or other uses of the setback, but the intent to do so should be stated clearly and expressly. That's relative to the zoning ordinance in print, not us. In reply to my question, it appears that vehicles in the ordinary sense do not constitute structures. In an extreme case, a vehicle may be altered, installed in a more permanent manner, or otherwise be deemed to be a structure, but not when used as a motor vehicle, and so long as the Tilton zoning ordinance does not expressly regulate vehicles. Those three items essentially cover the question here. And that being said, I bring it back to the board as to how do you feel about what I've just covered?
Good. Sounds very thorough. I don't have anything else to add or question, but at some point in time here, if it's appropriate, I'd like to make a motion. If the rest of the board has nothing else.
If the board has nothing else, we can entertain a motion at this point in time.
Very well. Kind of put this together just before the meeting started, so it would make sense. It's relative, of course, to the appeal of administrative decision at hand. And based on the advice of counsel and a review of current zoning ordinances, along with testimony that's previously been presented, I move to grant the appeal, overturning the planning board's interpretation, and allow the use of setbacks for driveways and parking in as much as the ordinance does not specifically address such use or uses. Is that too lengthy? Do you want me to
No, I
repeat
think
it?
that's fine. Quite clear. That covers everything. Looking for a second?
I'll second.
We have a second. Any further discussion? In that case, all in favor?
Aye.
Aye.
Aye. Opposed? Okay, well, that solves your problem.
Yep, sure did. Appreciate the
You don't
time.
need to go any further with that.
No,
Appreciate it.
You're good to go.
have a good day, folks.
Thank you.
Appreciate your time.
You as well. I guess I better give you this, huh?
You go right into this one.
That's all Thank you. Do you want this?
I think that's the fact you said I work for the town of Tilton. I obviously don't work for the town of Tilton anymore, I would know that.
Thank you.
I think you should have said that at the time.
Make any
You don't
difference.
care. I don't
It wouldn't have made a bit of difference.
No, you're right.
That was loaded against us anyway. That was loaded against it anyways.
I'll be in
Back to the plan.
620.
I understand that. That's the only reason I'd say back to a non-crash.
I guess we ought to make that clear that the vote in favor will constitute 4 affirmatives and one
One abstention.
one abstention.
Okay. I wondered about that, and I was
You
going to
might-
ask.
you probably should mention that Mr. Glank was the one that abstained also,
I will.
so that,
I did that in light of the fact that there was an objection to my being impartial.
I understand. Okay, time being 6:25 now, we can move right on into the Devere Auto Sellers, wholesalers issue. And in light of what you've just heard, which does seem to apply to your issue also, you have the variance for that, to actually be able to do that. You got that the last meeting. So where we are here is basically, the way I see it, you do not need a variance. That you
concur.
you can do that. However, we should have a motion to confirm that they do not need a variance. Would you agree with that, Bob?
I would.
Hmm?
He doesn't need a variance, he doesn't need a variance. There's no vote to be taken,
But the
no
whole board,
motion to be made.
but the whole board should acknowledge that. I would think, not me.
I mean,
Oh, I thought.
I think it could go either way. I was gonna respectfully ask the board to say that for me to withdraw the application entirely if legal counsel for the town
I could agree
made
more.
that determination. But if you wanna vote that we don't need a variance for that, then that's fine with me. I'm with you. That doesn't make any difference to us.
No, we poll the board.
I'll move that a variance is not needed in this particular case.
Okay.
You were gonna poll the board, you weren't gonna accept the motion, last time I heard you.
Well, I'll tee off the motion. I don't need to poll the board because the board's going to be polled.
Okay, boss.
Sorry.
Okay, have a motion on the floor. Do we have a second?
Second.
Your second?
I'll second.
Can you go over the motion again? The
I'm
motion
sorry?
is what? What is the motion?
Motion is simply that a variance is not required in the case of Jaguar Auto Wholesalers.
Okay.
Variance. Variance is not required.
Any further discussion? Okay, all in favor?
Aye.
You didn't ask for any discussion, but at the board meeting, I didn't speak up. My point is that I'm going to vote against it because I don't believe I know it isn't necessary. You indicated it isn't necessary, and the proponent has indicated they would withdraw their application, which is the way it should be handled, in my opinion.
Well, so noted. We have 4 affirmative votes and 1 negative. So it's a matter of fact now,
Okay, great.
where it stands. And
I drove by the other day and noticed that the vehicles have all been moved back.
Yes, sir.
And it looks good.
Thank you.
Before it was, it was like in your face, especially coming westbound. Not so much anymore. It looks very, very good.
Thank you.
Back like that.
I agree.
Neat, a lot neater. But still, the presence is there. I mean, you can't miss it. So, good job.
Thank you very much.
Well, thank you.
thank you. And we just cover the minutes of the last meeting. We'll conclude this meeting.
Have a good night.
Okay, good night now.
Thank you.
16 pages. Then it's 16 pages.
Gee, yeah, we definitely heard some testimony, didn't we? I've read these before, I didn't find anything that I felt needed to be corrected. It all looked good to me. So I would make a motion to approve the minutes of January, of April 17th as written. Mr. Chairman.
I'll second the motion
Thank you.
Thank you. All in favor?
for acceptance of the.
Aye?
Aye.
Abstention, I wasn't present.
Right, I understand you weren't there, I understand.
Very good.
Okay, that,
We're all caught up. We have no new cases going?
that being said, you'll all notice that the one thing that I didn't cover was the administrative gloss, because it doesn't become applicable to this situation now. But however, it's there for future reference should it be brought up.
Right.
And I plan on giving this to Sandy, who is the ex officio of the planning board, so they'll have that letter.
Can I have a copy of the letter to put with this?
No, you can't have anything. Sure. I plan on giving you.
Thank you. I was wondering.
That being said,
Motion to adjourn.
is there anything new to be brought up? Anything old? You know, I never did look in this thing. Is there anything in there I gotta?
The other thing is the town and country, New Hampshire Town and City, town and country, town and city.
Oh,
Found something.
down at Sandy. Well, Sandy's gonna bring one home.
I am working on some changes to the rules and procedures, and I'll try and get the draft down soon, Gus, so that you can type them up and get a copy to everybody to look over
Okay,
before we meet again.
okay.
A couple of items, a couple of areas in there that we need to address
Okay.
that are either missing or badly in need of updating.
The rules of procedure for the planning board, right?
Yeah,
Yeah.
for us, for the
Right.
zoning board.
I mean, for the zoning board, I'm
Yeah.
sorry.
Would you like to take that home with you? You have indicated.
Have you read it?
Well, Sandy will bring one home, so I don't think
Okay, thank
They have a
you.
lot of really interesting stuff.
Oh, I read these, yeah.
I read them all the time, yes.
I'll get it back.
Especially when you know about that.
So, thank you again, Tom, for joining us,
You're welcome.
and for such a beautiful job on the Grange. My God, that's that was quite a transformation. I really enjoyed that tour. Sorry I didn't get a chance to chat with you more about it, but
Well, you're welcome.
I spent some time in the kitchen area, especially. That's-
Isn't that amazing?
yeah, that's true.
Yeah, don't triple.
Make a motion to adjourn?
Great job.
I made the
Motion we
motion 5
adjourn.
minutes ago.
Yeah, Tom
Okay,
made
Tom
the
makes your
motion.
motion.
Okay.
I agree with
I know you
Tom.
weren't listening.
Yes, we listen to you.
No, Joe doesn't.
Stop.
How are you, Joe?
I'm doing okay.
Good.
Very much. How are you doing?
Like your outfit there.
It's a mix.
Tammy